Hello, everyone. Thanks for joining our webinar today. Before we go over today's agenda, I wanted to remind everyone that we will be continuing our series of special edition webinars that will include comprehensive information about the One Big Beautiful Bill Act. We plan to offer further coverage on this during the upcoming Tuesday webinars for the rest of this month and then into August. So in terms of today's agenda, we have Roger Bearden from our Albany office, who will kick things off. Roger will be discussing what lies ahead for healthcare and human services now that the One Big Beautiful Bill Act has become law. Next, we will have Samuel Wiles from our New York City office to discuss New York's attempt to backfill responsibilities traditionally left to the National Labor Relations Board. He will also talk about President Trump's recent NLRB nomination. Okay, I will now turn things over to Roger. Roger?
Well, thanks so much, Carrie, and pleasure to be here again. I'm venued in the Albany office, and I do work in the government and regulatory affairs space as well as the healthcare space. And I think as we're doing this set of discussions around the Big Beautiful Bill Act, or I'll just call the Act, the thinking about healthcare and its impact, one of the biggest questions is going to be, how will New York State react to a number of the provisions within the bill? So some of the things in the bill, in fact, create immediate or nearly immediate effects. Others are going to create decision points for the state over the next several years. So a lot of, when we're looking at its impact on healthcare in New York State, which has really been our focus, a lot of the questions are going to be what happens next. I would recommend to folks, there is a piece that my colleagues Kadeen Maitland and Gabriel Overfield put together, and that's available on the Bond website. A few themes when looking at the bill and its impact on healthcare. The first is there are a number of provisions that either directly or indirectly restrict eligibility for Medicaid services. So under the tail end of the Biden administration, there were some rules that were intended to streamline eligibility, to make it simpler for people to establish their Medicaid eligibility. And the bill simply notwithstands and puts a moratorium on those rules. So that would be a reversion to the practices that existed prior to that streamlining initiative. In addition, there are a set of requirements that have to do with a state making determinations with respect to individuals. So redetermination of eligibility to occur every 6 months rather than every year, a monthly redetermination with respect to whether individuals have died and therefore are ineligible to receive services. There's also a parallel provision having to do with determining whether providers, these would be individual providers, not not-for-profits or for-profits, have died. There's a provision having to do with whether individuals may be receiving services under the Medicaid program in more than one state. And those set of provisions are going to create for healthcare providers a lot of paperwork, a lot of back and forth, and a lot of potential for people to drop in and drop off of coverage in ways that are really unrelated to their underlying situation. The biggest of these new requirements have to do with community participation, otherwise known as the work requirements, which require adults between 18 and 64 to demonstrate either up to 80 over 80 hours a month of work, community participation, or work readiness activities. There's some exemptions having to do with people who have disabilities that would prevent them from being able to work. But what the experience has been in states that have voluntarily implemented those types of requirements is that really, this creates a lot of back and forth and a lot of paperwork that exists meet the demonstration, and the failure to make the demonstration, even if one is in fact working or engaging in work readiness activities, would lead to the denial of Medicaid coverage. So what's uncertain at this point is how that will be implemented in New York State, what that will look like from an operational perspective. There's a couple of years for that to come into play. But unlike the previous rules, which were that such work requirements were optional for states that wish to establish them, they are now going to be mandatory. Once again, the impact will be, patients that may have coverage, today, may not have it tomorrow, and may have it again the next day, depending upon how that will work out. On the state's finances, probably the single largest item is the sharp limitation on what are called MCO tax, managed care organization taxes. And the way those work is that the state will tax a payment being made to the managed care organization, realize that tax as general revenue, and then bring down another federal dollar. So it's a way to generate additional federal dollars without spending additional state dollars. Right at the end of 24, the state sought and obtained approval from the outgoing administration for those taxes. And there's been some regulatory work where the Trump administration has said that that's not something they would be renewing. And then the bill sits on top of that to make it very likely within the next year or so that that provider tax is not going to be a source of revenue. When it was adopted back at the end of last year, the estimate for New York State was somewhere around $3.7 billion over 2 years would be the revenue derived from this MCO tax. So once again, it's a tomorrow decision for the state legislature and for the governor to figure out how it is they're going to make up for that revenue shortfall. And this is also going to be a product of conversations that happen between the state and the federal government with respect to the implementation of the bill. Similarly, but with sort of a longer time frame, the bill has restrictions on the ability to engage in provider taxes. Now, provider taxes are very similar to the managed care tax, except they're more long-standing in New York State. Once again, it's a tax that goes against the provider. The provider's made whole, but the revenue is used to draw down additional federal dollars. That impact, just the way the bill works, is probably not till 2031. So it's probably not an immediate concern for folks, but as the state does its long-term planning and as providers within the state do that kind of planning, there's going to be significant revenue impacts in the out years. On the theme as well of coverage, New York State, as a product of the New York State Constitution, has offered healthcare coverage to non-citizens. It's about 500,000 non-citizens under an old court case called Aliesa. And that is something for which federal subsidies were made available under the Affordable Care Act. So it started with this Aliesa case in the mid-90s. And the court said there's a state constitutional obligation to provide care to non-citizens. And then New York was able to get federal support for that obligation. That's going away under the bill. So then the question becomes, what does the state do if it continues to have that obligation? Does it seek to relitigate those things? Once again, this will have the similar impact to the eligibility determinations, meaning that folks will have a coverage, and then they may not have that coverage in the future. And how will they then accommodate that as providers, and what the impact will be on state charity care as well. Sticking with financing, the vast majority of New York State Medicaid program runs through what's called the 1115 waiver. There was an expansion of that waiver to provide for health-related social needs. Once again, near the tail end of 24, that was authorized. There have been both regulatory initiatives and some guidance documents that have issued under the Trump administration, and now the bill that sharply restricts the availability of 1115 funding. And that's where a lot of the innovation work has happened and where a lot of the new investments that are made in providers have been. So once again, not yet really known how the state will react to that, but that's another several $billion shortfall that's projected in the out years that's going to be impactful. One thing that is certain, if one runs a nursing facility, the bill does not withstand the rules established under former administration regarding nursing home staffing. As in everything in New York, when it comes to the regulatory environment, it's complicated because prior to the federal regulations, there was a state statute that was adopted at the end as a consequence of some of the COVID issues that mandates staffing ratios in nursing facilities as a product of state law. So there was a significant question for those in the nursing home industry. I've got a federal reg, I've got a state law. The two are meaningfully different and not easily reconcilable. How do I come up with a plan? That at least is simplified to some degree, which is now there is the state law and the compliance with that. I would mention as well that there are sharp restrictions to providers of abortion services, but that once again is a relatively limited subset of impacts. I think I have exceeded my allotted time by a minute or two. If we do have time at the end and there are any questions, I think those can be put in the Q&A, and I'd be happy to answer those or take them offline. And with that, I don't know if I'm supposed to throw the mic to Carrie or throw it to Sam.
Thanks, Roger. I'll take it, and I'm just going to turn it back over to Sam. So now, everyone, we have Sam up to discuss the NLRB issues. Sam?
All right, thanks, Carrie. My name is Sam Wiles. I'm an associate in the New York City office. So I'm going to cover largely a bill pending right now before Governor Hochul. That would be an NLRB trigger bill, kind of discussing that in the context of where the NLRB is right now and kind of what it means for employers over the next, 6 months or so. So just briefly, the NLRB is a 5-member independent agency with members appointed by the president. The NLRB governs private sector labor relations and labor disputes across the country for the purpose of creating national policy and a consistent framework for resolving labor relations and labor disputes. The board needs a quorum, though, to work fully, and a quorum under the National Labor Relations Act requires the board has 3 members on the board. Largely since January, the board, however, has been without a quorum because President Trump fired member Gwen Wilcox. The termination of her membership is disputed, but essentially since that time, the board has been without a quorum. So what does it mean when the board lacks a quorum? It means that the board cannot certify elections, it cannot issue new decisions, and it cannot promulgate new regulations. So everything that's still on the board, or all the precedents over the last few years, are still there. Arguably, there are other things that the board can't do without absent a quorum. Things are disputed, but people are arguing that ALJ hearings can't proceed, elections can't be processed, NLRB, ULPs can't be investigated. Likely they still can. The board is able to and has delegated a number of these authorities previously in consideration of the fact that a quorum might not always be present. So really what has happened since President Trump has fired Gwen Wilcox, the board has been without a quorum. It hasn't been able to issue new decisions. It hasn't been able to change any regulations that are on the board. And no new members were announced really until last week. So really what this has meant for, labor relations and all this is that all these standards have been on the board for the last few months. The board has been inactive, and states like New York, California, Massachusetts have seen this as an abdication of the federal government protecting workers' rights. So a few legislators in the states, including New York, have passed or brought up legislation enabling states to take on the NLRB's authority in the absence of a board quorum. So I'm going to discuss New York because I'm not a California or Massachusetts attorney, so I'm going to stick with what I know best. So New York passed a bill S8034A. This legislation allows the state to step in where the NLRB cannot act due to a lack of quorum. It's what is referred to as a trigger bill, and will take place whenever the board lacks quorum. So this bill amends Section 715 of the New York Labor Law to provide coverage for private employers that are normally covered by the National Labor Relations Act when the NLRB declines to assert or cannot successfully assert jurisdiction. So it would give authority to New York's Public Employee Relations Board to oversee labor disputes in the private sector in the event the NLRB cannot assert jurisdiction. There are arguments within the act of whether this is permissible or not, but for the reason I'm going to say now, while this is pending before Governor Hochul, it is likely a dead letter upon arrival for a few reasons. It's not to say that employers shouldn't be aware of it, and I'll discuss that later too. But first, it's probably dead on arrival because it's likely preempted. A Supreme Court precedent holds that the NLRA generally preempts state and local laws that attempt to regulate private sector labor relations. Again, this is with keeping with a national policy of labor relations and consistent throughout all 50 states and territories. There is some areas where states are permitted to regulate, and the NLRA makes this clear. That's largely for public sector employees and agricultural employees. The second reason is that the board will likely have a quorum again soon too. So President Trump nominated 2 members, management-friendly side members, who should be appointed probably in the next few months, or will be nominated and placed soon. Essentially, which would nullify any trigger effects of this bill, even if it was signed into law. I bring this up too. So one of the reasons that this bill is important, even if it's dead on arrival, is that it shows that New York and other states are going to be probably over the next few years increasingly likely to push the envelope or step into gaps that the federal government might not want to fill, or that they feel is an abdication. New York has been already pushing this envelope in terms of farm labor and agricultural organizing and labor protections. So New York passed the Farm Labor Fair Labor Practices Act, which is similar to the NLRA, but governs farm laborers. This has been a boon to some of the unions seeking to represent agricultural workers in New York. A few have already formed unions and have represented farm laborers at farms across the state. So the UFW has launched a campaign in New York and California as well, seeking to represent farm workers. I imagine that this is likely going to be, pardon the pun, but a fertile area for organizing over the next few years, particularly given the administration's moves on the immigration front. There'll be new organizing activities with farm workers. States like New York have also taken to trying to regulate other areas that the NLRB typically regulates. So some states have created captive audience bans, some of which have already been struck down, but hasn't stopped states from trying. So states like Alaska, California, New York, New Jersey, Connecticut have all tried legislation like this. So legislation like the New York Trigger Bill and these captive audience bills, farm labor bills, I think we can expect to see some more things like that on the near horizon. Just to kind of conclude briefly, but going forward, the board is likely to have a restored quorum in the near future, like I was mentioning. So president has nominated 2 members. One is Scott Mayer, who is chief counsel at Boeing, and then James Murphy, who's a long-term NLRB attorney. The general counsel for the NLRB, the nominee for that is Crystal Carey. So she's the going to be the main prosecutor and sets labor policy She's going to be probably in place shortly too. She's a management side attorney, having worked previously for the board and Morgan Lewis. So she is probably going to step into that role shortly, assuming she is confirmed. But right now, what employers should be aware of is that all the precedents that many employers do not think of as so friendly from the last few years are still on the books. So while there hasn't been much activity with the board in the last few months, decisions like the Chemex decision, the Cemex decision, went McLaren dealing with separation agreements, decisions dealing with captive audience meetings, employer speech. Those are still on the books, and employers are still expected to comply with those until they're overturned. And that will only start happening once new members are appointed and start overturning these decisions. I think you can expect other states like New York to continue pushing back on areas where they think that the board is not living up to its mandate. While these efforts might not be successful, I think you're going to still see states trying to see opportunities where they can advance workers' rights. I wouldn't expect anything like Senator Sanders' PRO Act, which is a way to augment the National Labor Relations Act, passing anytime in the near future. But I think you can still expect to see significant organizing activity, and likely, especially in New York, you might see more farm labor organizing going forward soon too. So right now, I would say that this is notable. While this again might be a dead letter on arrival, it's notable in showing that states are not going to just stand back and let inactive federal government or federal regulatory structure go unaddressed. Whether this includes worker protections in other areas, we'll see. But in terms of labor relations, I think states are going to push where they can. Again, steps now. The NLRB is still functioning to the extent possible. So regions are still issuing complaints. They're still investigating charges. ALJs are still issuing decisions. Employers are still expected to comply with precedents on the board. And largely you're still expected to comply to the extent permitted by law. Unions are still filing election petitions. Employers should still be on the lookout for those and should still be in compliance with all standards still on the books. But it's an exciting time, and I think once these new members are appointed and come on board, I think there's going to be a lot more activity with the board in terms of decisions coming out and reversal of a lot of these standards that came out during the Biden administration. So I'll leave some time for questions, but thank you all for your time, and happy to discuss.
Thanks, Sam. We appreciate your update. Someone in the Q&A asked for the bill number of the legislation that you just discussed. Do you happen to have that handy?
Yes, let me try to read it because I have it in small font here. It's Bill S8034A.
Okay, perfect. Thank you. And we had one other question in the Q&A. Roger, this one is for you. The question is, does the term non-citizen also refer to legal resident aliens?
Yeah, and I appreciate the question because I was using some shorthand here. The bill, the BBB, the bill excludes from Medicaid coverage those who are, well, it includes citizens and it includes aliens lawfully admitted for permanent residence, an alien who has been granted refugee status as a Cuban or a Haitian entrant, and then there's a very small Micronesia and Palau exemption. So if you don't fit into those categories as someone who is lawfully admitted to permanent resident for purpose of permanent residence or a citizen, then the bill would exclude. I should mention as well, if you're in the healthcare space, I just want to validate and build on Sam's point that a lot of the action is happening right now in the repeal and non-enforcement of regulatory and guidance documents. So it's something that if you're in those spaces, and this tends to be very sector specific, it's something to track and be aware of.
Great, thank you, Roger. And that's all we have for today. I want to thank everybody for tuning into the webinar. We again have all the contact information for today's presenters on the screen here. Please feel free to contact any of us with questions. Gabe will be hosting the next webinar next Tuesday on July 29th. Please join him if you are able to do so. Have a great rest of your day, everyone.